Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
Now let's get straight into it this week, Dennis. What's the latest concerning the government's approach to senior appointments during the pandemic?
Helen, the judgment in the Dido-Harding case was handed down last week, so here's my summary of the case. The High Court has handed down an important judgment in the case of the Crown on the application of the Runnymede Trust and the Good Law Project versus the Secretary of State for Health and the Prime Minister. The claimants had argued that the closed and unremunerated appointments of Dido-Harding and Mike Coop were discriminatory and breached the public sector equality duty, and that Mike Coop's appointment was tainted by apparent bias. Now, the court found that the Health Secretary had breached the public sector equality duty in relation to the decisions to appoint both Dido-Harding and also Mike Coop. The court held, however, that the appointments were not discriminatory and that the principles of apparent bias did not apply to employment decisions such as this. The judgment also contains some significant analysis on the question of standing of campaigning organisations to bring judicial review claims, as well as standing in the context of discrimination claims generally. Now, this case is just one of a number of cases where the government has found itself on the wrong side of the law in relation to decisions taken during the pandemic.
Well, as you know, Dennis, the Judicial Review Bill is undergoing significant examination in the House of Lords at the moment. Watch this space, I guess. Now, the Health and Social Care Bill had its final stage of committee in the Lords last Wednesday, when the Minister, Lord Kamal, said that following the strength of feeling in the House on the issue of and draft guidance on elected councillors being appointed to integrated care boards, the government had made the decision to revise its draft guidance to remove the proposed blanket exclusion of local authority members sitting on ICBs. He added that although ICB members from local authorities are normally likely to be officials, local councillors will not be disqualified for selection and appointment to an ICB. The LGA welcomed this announcement as a helpful recognition that councillors can make a positive contribution to ICBs, bringing a wealth of experience from working in partnership with their communities and other stakeholders on strategic issues. The bill will now move on to 4 days of report starting on Thursday, the 24th of February. Amongst amendments the sector are pushing for are those which would require the Secretary of State to consult with relevant health overview and scrutiny committees regarding NHS reconfiguration proposals. Details of the amendments and overall view on the bill can be found linked in the bulletin to the LGA's committee stage briefing. Moving on, I understand the government are planning changes to support domestic abuse victims to obtain safe accommodation. Dennis.
Precisely, Helen. Key consultations have been announced last week, and the main one concerns housing allocations and the local connection criteria. Here's my report. The Department for Levelling Up has launched a consultation seeking views on proposals to introduce regulations to enable victims of domestic abuse to qualify for an allocation of social housing in a new area. The consultation will also examine how local authorities are currently making use of existing legislation and guidance to support victims who wish to move within and across local authority boundaries. The topics covered by the consultation include the current priority given to domestic abuse victims for social housing allocations, the social housing allocation qualification criteria for domestic abuse victims generally, and also the scope of proposed regulations for removing residency requirements and local connection tests for domestic abuse victims. The consultation runs until the 10th of May, and the proposals relate only to England. Local connection tests for social housing allow local authorities to prioritise applicants who can demonstrate a close association with their local area. Local connection is usually established where people have lived in an area for at least 6 months out of the previous 12 months, or 3 years out of the previous 5 years, or where the applicant may have well-established family or local associations to an area. Now, LLG will report further when any new regulations are announced.
Turning to more internal matters, the SRA have published the findings of its workplace culture thematic review, stating that creating a positive culture is crucial for the effective operation of law firms. Their review looked at how firms can create such a workplace where employees feel supported, risks are managed, and clients are protected. There are, of course, many parallels for the in-house local government board. The SRA carried out its review by examining how firms support people in the following areas: managing client pressures, management of workloads and allocation of work, reporting mistakes and near misses, supervision, learning and development, measuring performance and reward and recognition, and recognizing the signs of poor mental health and helping people to speak out. It also explored the effects of the COVID-19 pandemic on culture in firms and how this may influence working practices in the future. They found that the most respondents felt that their firm had a positive workplace culture, with slightly more agreeing that their immediate team or department were positive. Overall, supportive senior leaders and line managers played a crucial role in creating this culture at firms. Some common themes from the review were the importance of engaging and involving employees in decisions about their culture, creating a psychologically safe environment to speak up about worries and concerns, the value employees placed on support from line managers and colleagues in teams, the benefits and challenges of remote working and its effect on trust, balancing well-being with commercial requirements, and a disconnect between the actions of senior leaders and the culture they promoted. That said, a quarter of respondents felt their firm did not have a positive culture and highlighted concerns such as long working hours, pressures from clients and workloads, targets that ignored other achievements, and worries around reporting mental health issues and bullying behaviour. I wonder whether it would be useful for LLG to take a snapshot of the health and well-being of its local authority members. Let me know what you think. Now for something we don't usually talk about. Did you notice something in the air last week, Dennis?
Helen, love is in the air, and not just because it was Valentine's Day last week. Perhaps I should explain further. An article from New Local drew attention to Camden Council, who celebrated Valentine's Day in a rather unusual way. 130 people from across the country and from a range of organisations came together to talk about love in public services. Yes, I did say love. Relationships Making a Difference seeks to challenge the idea that love and public service are incompatible. Liberation, love and action, inclusion and connection were all on the eclectic menu. The event was facilitated by local residents and public service workers. Such was the appetite for the event that it sold out within just 5 days. The word love has hardly been synonymous with public services in recent times. The years of new American-style performance management, where cold transactional processes have triumphed over the need for closer relationships with people, have given public services an unenviable, soulless reputation. The sector's image has largely become that of robots remotely churning out services and dispassionately calling what we do service delivery. Yet, I can remember a pre-Orwellian time in local government, before the myth of customer orientation took hold, and before we had creatures called stakeholders circling around us, and when we used ordinary, meaningful language to describe what we did. Customer relations management these days, sadly, usually means the entire opposite of what it says. But now, local public services up and down the country are quietly rebelling against these alien and inanimate phenomena, and people are writing new narratives with aspects of love as a central protagonist. Today, relational practice is undoubtedly on the rise, with green shoots in social care, housing, education, and health, to name but a few. Don't just take this from me. Take a look at what's happening in London, North Dorset, Wigan, and Leeds. Is this just soppy or unrealistic? What's love actually got to do with public service? Quite a lot, as it turns out, and we must never, ever let those aliens win.
My last item is rather sobering, but of the utmost importance to take stock of following research by the Nuffield Family Justice Observatory, which found that the number of applications to the High Court to deprive children of their liberty in unregulated settings when a place cannot be found for them elsewhere has increased by 462% over 3 years. The report found that many more children are referred for a place in a secure children's home on welfare grounds than can ultimately be placed, and that there is some evidence that there is a cohort of children with particularly complex needs who were seen as too challenging to be suitable for a secure children's home. This includes children with very complex mental health needs, but who do not meet criteria for detention under the Mental Health Act. This, it says, has led to a significant increase in the use of the inherent jurisdiction of the High Court to deprive children of their liberty in alternative placements. The Observatory notes this is a major cause for concern, given that we do not know where these children are placed, what restrictions are placed on their liberty, or what their outcomes are. The report went on to find that there is a lack of systematic and longitudinal research about children's outcomes following secure care, and urged the use of a consistent set of outcome measures, which would follow on from an agreed set of aims, statement of purpose for settings, would at least be a help, stating, quote, "There is therefore a need to rethink how we meet the needs of this group of children, based on a better understanding of their journeys, strengths and needs, what a positive outcome would look like, and the type of trauma-informed, therapeutic and integrated care that would support children's resilience and recovery, both in secure settings and in the community before, after or instead of a placement in secure care." Let's hope that rethink comes sooner rather than later. And on that note, that's it from us for another week. You can find more on these issues and many more by going to Bulletin 7 in your inbox or on our resource pages of the website. And whilst we iron out changes to our notifications, don't forget to check your junk box, just in case your bulletin has erroneously found itself in there. It's goodbye from me.
And goodbye from me too.
Thank you for listening. Have a good week, everyone.